Yep, okay. Oh,
Here comes Sam.
There we go.
There we are.
Good?
okay,
we're
great. All right, good evening. I'm calling to order the Southborough Zoning Board of Appeals for January 22nd, 2025. We are now on Zoom as well as in person, so thank you for the efforts of the IT person. So two of our members are remote tonight, Paul DePranos and Mike Robbins. On the agenda tonight, the first thing we have is a review of comprehensive rules and regulations. And that is really going through our internal rules and regulations and getting up to date with recent state code. This is work that has really been done by Laura and Jay, so if you could, if you don't mind, either Jay or Laura, you want to just kind of walk us through what's updated, or at least the significant pieces of it, maybe?
Yeah. Really quick, just because it is technically a public hearing.
Oh, sorry,
Okay.
you're right.
Um,
Right into it.
Board of Appeals of the Town of Southborough will hold a public hearing in the McAuliffe Hearing Room Wednesday, January 22nd, 2025 at 7 o'clock p.m. with regard to proposed comprehensive permit rules and regulations per the Southborough Town Code, Section 43-2.
Thank you.
So, what we did, so Laura did a lot of the work in terms of getting the initial draft done. And then what I did was take the rules and kind of compare them to some other ones that I've done, because we routinely do this, and then kind of modernize them so that they kind of matched what we know to be the case law, the history. And then some other changes I made related to things that were kind of either repetitive of what we can already do, or things that I wouldn't want to have fixed in the regs, but would want to give you discretion to do. So towards the end of the regs, I had a lot of deletions. And those are the kinds of things that, and you know this because we just did it in another permit, we would put in a permit or in the documents following the permit. So I don't like to fix those in the regulation, even though we can change the regulations whenever we want, as long as we hold a hearing. There's no need for them to be here because we already have that authority. So when you saw a whole bunch of crossouts, especially towards some of the latter periods, we either have that authority or it's just duplicative of what already exists. I did make a bunch of changes because it's not DHCD anymore and because they've changed some of their stuff. I added some things to make your review a little more fulsome, and we can go through it, like the various changes or just answer questions. Like I added areas of review in terms of like environmental, neighborhood impact, those kinds of things that are pretty natural to this. Changed a couple things here and there, as did Laura, to conform with more current language in the town's bylaws. The terms for different entities.
Select board, right?
Yeah, select board, things like that. Otherwise, I mean, the gist of it is mostly the same. But I just kind of brought it up to date a little bit. So.
Okay. I'd like to just quickly ask the board members. I mean, I prefer that we kind of go, they lead us through it. I don't know if anybody's done a very detailed review and has their own thoughts and questions before we begin.
So I've read it. I probably have like 5 minor comments, but we can just go through those as we go through it.
Okay.
But I did read in detail. I thought overall it looked great, but I had some couple additions or minor questions as we go through
Sure.
it. So.
Okay.
Yeah, we can go through it section by section.
Yeah.
I'll try and summarize where I can summarize.
Okay.
But otherwise, we can go through it. So, section 1, it's kind of like just the history and how we got here, what 40B is, what we try and look at under these 40B projects, the source of the authority to adopt regulations is there, introduces some of the players, describes some of the additions I had, where there was a line in there kind of halfway down. The need for affordable housing must be considered within the context of such issues as public health, safety, promotion of improved site and building design, neighborhood character, infrastructure impacts, which always comes up, environmental concerns, open space preservation, et cetera. So I added some there, made a bunch of changes on the regulatory names, and changed DHCD to EOHLC. So that's most of the changes to section 1. It's really just a preface,
Yeah.
so to speak.
David, Mike.
If I can briefly, I just want to make sure I'm looking at the same documents that Laura sent out on December 9th. I just want to make sure there's nothing else that I've missed.
I believe that's the same one, because I
Okay,
sent out
I
the
thought
link.
I hadn't
Yeah.
seen anything subsequent. While I'm going through these again right now, I just wanted to make sure I'm reviewing remotely the final, the most recent version.
Absolutely.
Awesome, thanks.
Section 2 is just the definitions. I always contemplate doing more definitions. These are kind of the ones, the regulations under 40B have a lot of definitions in them. We don't have to repeat them here. They apply to us. I think it's important to kind of give a couple of them to talk about local board. I do see where we say Board of Selectmen in 2.3 that we should probably change to Select Board. But those are really kind of just repeats of 3 of the many definitions that we see in the 40B Regulation 760 CMR 56.0.
Jay, one quick question, just with the recent Milton case, and part of it, the state is doing new 40B regulations, and I think they issued emergency regulations too. How does that affect this, if anything?
So
right now?
the Milton case doesn't affect it all.
Yep.
The new 40B regulations also don't affect this process. The new 40B regulations have 2 components to it that are important to us, and we can get into that a little bit. It's more likely going to come up in real time. They changed one of the processes, and it's still in the works, to develop the land area minimum calculation that is a safe harbor. And the other thing is they changed the regulations, actually made it easier for towns, but quicker for developers as well. When a town does claim one of the safe harbors, whether it's recent progress towards 10%, or a size, a large project, or repetitive petition, those kinds of things, it simplified that. Those were the 2, really the sum total of those 40B regs. None of that is addressed in these regs. Those are really important because any town could come up against that. In fact, right now, I have 3 or 4 projects involving safe harbors. We haven't had a situation like that. We may, as we inch closer to 10% in this year, even just our recent progress may come up, so that does affect us. If we get another project that significantly increases our overall housing load, then we may be able to use some of these provisions. They're actually good for both towns and developers. Rare that they change a reg that actually helps us as well as the development community, but it is actually a pretty good change on
Okay,
that.
great, thank you.
So, and the Milton Common stuff, that's the
Yeah.
other bylaw.
Correct.
So, I mean, indirectly impacts us because it may be a tool for some developers to approach by right opportunities as opposed to these opportunities. And those projects may also throw off a little affordable housing, which makes our job easier here as well.
Okay.
So, okay. So, an initial process, Laura and I kind of brought it into kind of current, we talked about the business administrator for the Zoning Board of Appeals is the entity that gets the application. We eliminated Shopsy from the mix, and there's a couple provisions there. we talk about town department review, all the entities that we would like to review these things ahead of time. Again, we replace SHOPSI with the Affordable Housing Trust Fund Committee. Conservation Commission, we add stormwater issues to their review. That review may also come from other sources, obviously our own. Planning Board may also chime in on that. DPW may chime in, but Concom, when it comes to wetland impacts, they will certainly focus on some stormwater stuff. So, and then we added there that other reviews as recommended by the building commissioner, the town planner, or the DPW director, because they may say, wow, this is an interesting project. We want to look at it from a tree warden perspective or some other perspective. So I just wanted to make sure we had a good, strong catch-all there. Again, not super binding on anyone, but kind of important to do.
So one minor comment, and I promise you my other ones are more substantive.
Okay.
3.1, second paragraph, second line. This is on the clean version. Prior to the submission of application to keep, I think it's just to keep the neighbors, there's an extra "and" in there.
So tell me again, so
Second-
3.1, second paragraph,
Second line on the clean version. So it says prior to submission of application and to keep, it says "and the neighbors." I think it should just be "keep the neighbors." Minor, so
No,
minor net.
Important, thank you.
Yeah, so,
okay. 3.4, I did strike this thing about, so it says an environmental notification form under MIPA may be required. So it's not for us to say what is required for environmental notification form. That's someone else's jurisdiction. So I wanted to stay away from that. And if there's an environmental notification form out there, we want it. We want to see it, and we're entitled to it. Most of the time, the ENF is going to come well after us. And there's actually state regulations that talk about the requirement to provide that as part of the 40B process. But developers normally do that after the fact. Sometimes they do it before us because there's something else going on, wetlands, that they want to square away or something. We may see it ahead of time. I struck the stuff, it says may be required if a comprehensive permit is proposed for more than 100 units. Again, not for us to tell them when it is or isn't required. If they're required to do an environmental notification form, they're going to be required to do it anyway, and eventually we'll get to see it. And I just say may be required if the application triggers one or more of the threshold requirements under MIPA. Again, that's just stating the obvious, but we're not in the MIPA business. We want to be informed of those things. If there's information out there that's helpful to us from a state agency, we want to see it, but I don't want to regulate it at all and duplicate those efforts. So, filing, time limits, notice, not a lot of changes there. I did change on 4.1.2.5. It says, the board may elect to retain service of a consultant pursuant to section 5.1 to review the details of the pro forma and to consider other relevant guidelines for the review of costs and revenues of a development project. There is guidance from the state as to when we can't, it's in the 40B regulations writ large, when we can and can't do that. And, but the language such as those as may be available from the Massachusetts Office of the Inspector General and those that may be available from Citizens Housing and Planning Association. So as to the Inspector General, there are none. They don't regulate or tell us how to look at a pro forma for identifying it. There are differences of opinion amongst the development community and the municipal community as to how to review a pro forma. That's the subject of some regulations in a few cases, but the IG doesn't have any of that information, doesn't get involved in the 40B stuff. They might if there's a fraud and they have to get involved, but they wouldn't get involved in the permitting end. And as to those that may be available from CHAPA, even if CHAPA currently had any of those guidelines, I wouldn't adopt them because I guarantee, and this is not, I don't mean this in a pejorative sense, that all inferences and presumptions in a study by CHAPA on that issue are going to be resolved in favor of the developer's side of the spectrum. There's a whole other school of thought from the municipal side of the spectrum. Normally, everyone falls right in the middle, but CHAPA is not a legal authority. They're a nonprofit that is kind of monolithically dedicated to the development of housing. And I mean that in the positive sense, but that is their world, and they're not a regulatory authority, and they shouldn't be relied on. DHCD, developed and now EOHLC, holds certain guidelines for the review of pro formas. It's a lengthy document. It's available to us. It's on the Housing Appeals Committee website. So that's why I kind of left it more as broad. And sometimes there are disputes over how to interpret a pro forma, and I wanted to preserve our opportunity to engage in that process. Usually we find a way to agree. Used to be that folks like me and Lou used to fight over what a pro forma means or says. Now, much less so, because everyone's kind of found a way to the middle on that, because we kind of understand. I don't really love the process, but it is where it is, based on what I'm seeing, what we've seen out of the cases. So, let's see, other things in section 4, under 4.1.3.9, I added that if there is going to be a subdivision plan, we want that plan to be in compliance with the plan requirements of the subdivision regulations. There's a great, they can always request waivers from those regulations, but there's a lot of great details that the planning board has worked really hard on to make sure that when we see a subdivision plan, it addresses things like road width, where the lots are, where the monuments are, the road construction standards, the curves, all of those other things. If they want to request waivers, that's fine, but we want to see the level of detail that we would expect they would be presenting if they had to go before the planning board. So nothing more, nothing less. I think the last project that we did, it took a while, but eventually the applicant developed a subdivision plan that kind of met those standards. So this is just kind of memorializing that process.
Jay, just to go back briefly, 4.1.3.6, I actually appreciate the added the buffer zones in, right? Because obviously those have been missing from the plans on the wetlands.
Yep.
One thing, I'm not sure where to add it, but we should also add a request for a limit of work line, which we've added on several projects.
Sure.
And I don't know where we've specified, not sure exactly where it should go, but it should be at least on the site
I
plan or
think
something.
maybe Laura and I will add it somewhere. Do you want to make just a note? We'll toss that in somewhere that the plan should include a limit of work.
I mean, the first one we asked, and the most recent one does have it, which is really helpful to see how much of the area they're
Pretty
serving.
common engineering standard, so I think it's a good thing for us to add. I add in 4.1.3.10 that for larger projects, we may, I don't want to say for all projects, if we get in with a 4-unit project or 6 or 10-unit project, or one building project that has 12 units, we may not require or need a landscape architect to sign a landscaping plan. But for larger projects, we may want to require, like there's a full professional landscaping approach to it. So I didn't want to say that was a hard and fast requirement because we'll see a waiver every time. I think we reserve the right to ask for it on something that is a complex set of landscaping plans. So, and it's actually really helpful. Those larger projects, like when we see 200-unit projects, it's almost always they're going to have a landscape architect anyway, because it's important for them to do it as well.
And Jay, this is one of my other comments, more for the board too. Given our last couple of projects, there is definitely from the Conservation Commission, or just generally, there's been a comment of a preference for native species. in landscaping, and I don't know if we want to add, I don't want to be too prescriptive, and again, it's just a preference for native species, might be something to add, just because it's the first comment we get every time from COMCOM or it comes up. Again, not a requirement, but something for the board to consider as an item to add, just to, I mean, it's going to come up, so why not put
Yeah.
it in the regs?
Yeah, I don't, that we should express the preference at the very least. So I think
Yeah.
you're making that note.
Yeah.
Okay. I think that's fine.
Yeah, I would agree.
The addition that we have in 4.1.3.14, I think it's just a smart addition. And we want to see that it meets stormwater management guidelines by DEP. Pretty straightforward. They all are going to be measured by that anyway. So that's going to be ultimately the review by any civil engineer. So I think that's important. 4.1.5, where I add for each building and projects of more than 4 units, it shall be signed by a registered architect. That's reflective of the requirements of the state.
Okay.
For something smaller, and I have seen a couple of 2-unit 40Bs, but for normally almost all of them are bigger than 4. I've
Yeah.
seen a bunch of 4s, so we don't necessarily, that said, most of the time they're going to come in with something architecturally designed anyway. So, but that's, the more than 4-unit thing isn't my standard or something that I've seen. It's something that the state has
Okay.
suggested is the standard.
I had a comment on that. I only had about 4 or 5 comments, Jay. So absolutely, I like the section and the fact that we'd want a mass registered architect. It's just a thought. I didn't know if we wanted to add language. Then in my experience is, do you mean you want to have, as an architect may sign that in Massachusetts, but the work performed outside of Massachusetts? Do we want to be more narrow, or it's just the fact we want a mass registered architect signing? A lot of the architectural firms are pretty big.
Yeah.
Yeah, I'm just saying, it's absolutely, so is the intent, you would have to be likely be a mass registered architect to sign a plan in Massachusetts, just by law, by an architectural license, but
I
the
mean,
question-
my
yes.
understanding is that they're going to have to, I mean, if they're, I don't think it's as strict as like being an engineer doing
Right, a
work in
PE, right, PE
Massachusetts
signs
or a
off.
lawyer, but I think if they're presenting plans for construction detail in
It's
Massachusetts,
just a question.
yeah,
Yeah, so,
I
yeah,
think,
well, because some of the firms are pretty large.
I know that
Yeah.
they're big, but I'm sure they use the big ones will probably use someone to stamp the plan.
Locally, but
would think
it's
so.
made in,
Even if
In another
someone
state.
else has it, there might be a couple of
Yeah.
stamps on it.
no, it's just a question, you wanted to make the language more restrictive, or you think that's adequate, and that's all.
I think it's adequate, shall be signed by a mass registered architect. I don't know. I mean, I'm happy to make changes to it, it seems.
I mean, I think it seems adequate to me just to say mass registered architect. Because I feel the same way. If you're trying to do a project here, I would think even if you're a large outfit, you would have some presence here or some relationship where you'd get somebody from Massachusetts. to do
Yeah,
that.
I mean, for example, like a company like Avalon, which does a lot of projects in Massachusetts, it's a Texas company, and they use plans that are probably done down in Texas, but there's always a mass stamp on it.
But that's exactly what I'm discussing,
Yeah.
right.
Right. So, I mean, that's what it says there in 4.1.5.
And that follows mass, is that mass guidelines?
I think so. I
Yeah.
think they say mass registered. I think it's fine for us to say it, certainly.
Yeah.
No, I want it. Wasn't that just, it's enough, that's all.
Okay.
Yeah.
Yeah, okay. I did have another tiny comment. I actually wrote too much about this in my comments, Laura,
Yeah.
because we're going to get further down. This is going to take a nanosecond. In 4.1.2.1 is, it says the pro forma shall be prepared by a certified public accountant experienced in construction and development. I just have a strong preference to replace the word experienced with the word competent.
Yeah, we might even want to, a lot of pro formas are not prepared by a CPA, actually. So we could probably take out CPA. So what was the word that you wanted instead of experienced?
Well,
Qualified?
CPAs can, but that's a strict requirement, it's a costly requirement to put a CPA on there.
Well, it's not a requirement for 40B.
Right, mm-hmm.
Most of the pro formas I see are not done by CPA.
That's probably because of cost. So if you retain the word certified public accountant, experienced, it's the word you, being a CPA, the word you normally would use is competent. You could just say prepared by a competent and experienced person in construction. I mean, you could strike certified public accountant because that is a costly requirement. They're not audited. They're just, I don't know how worthy they are if they're not audited, but.
What if we said an accountant or other professional that is,
If I may, competence is a subjective term, certified is fine.
Who's that?
That's Paul.
As Jay, or Paul.
That's Paul. Competent is that's a subjective term.
That is, yeah.
So if you're a certified accountant, that's adequate.
Yeah, we change. If you're a certified public accountant, the word is competent. If you're using another word, you wouldn't use the word competent, but specifically with CPAs. You just have to be competent. It's sort of a ethics and a regulation for CPAs.
Well,
the word
that's,
we use.
if
I-
you're
this-
certified, you're competent.
Right, that's what I,
There's no need to have this discussion.
well, you could just strike it entirely and back out
Yep.
experienced, right? I agree with
There's
that,
no need
too.
for this discussion. You're a CPA, you're a CPA.
All right, so what are we
By
suggesting?
Yeah,
definition,
so we're
you're
suggesting
competent.
a change.
So, all right, so what are we suggesting making a change here or not?
well, I want to say certified public accountant or other professional that is
Experienced in or competent in?
experienced in construction, development.
And then we need a second sentence, then it gets run on. But you can fix that. It says and.
So you want the competent following the certified public accountant.
Paul's correct. It's, if you can
yeah.
strike the word competent if you're a CPA, but if you're putting it and competent or experienced construction accountant, I don't even know it's such a thing, but,
I doubt it. So that's why I wanted to maybe just say the pro forma shall be prepared by a certified public accountant or other professional that is experienced in construction development.
Yeah,
I agree with the other professional adding it in.
yeah, I think
Yeah.
that makes sense.
Okay. All right.
The next was 4.1.8 was the next change.
Yeah.
I have another easy
Sure.
comment. This is in section 4.3. I think it's at the start of the section. It's about the copies, the 10 copies. And Laura, you probably can speak to this also. It goes, the applicant must file one full physical copy with town clerk, sounds good, and 10 physical copies and one electronic copies. And my recollection is a number of years ago, we had talked about all these copies with the application. Do we need 10 copies is what I'm getting down to.
So I think
Hard copy.
I think need is, so originally, before I took a chance at this, it was 26 copies.
Oh, my God.
So currently, what these poor people have had to submit is 26 copies, and I have binders on binders in my office because they don't go anywhere.
Okay, we're getting to it.
So I
Okay.
reduced it to 10 because what I do is I provide a hard copy to the Conservation Commission, a hard copy to the Building Commissioner, one to the Select Board, and several copies to the Planning Board. And then I like to have one in my office in case people come in and they want to take a look at it. So do we need it? No, but
Okay, yeah, so.
I mean, I think it's really
Yeah.
up to you guys. Our regular applications, we don't require a hard copy at all for us, but that's because they are submitted on our online portal. I have not yet found out a way to get our comprehensive permits onto the online portal just because they're so complex. So the website is the next best thing that I have to get it out there electronically to the public, but in case somebody wanted to come in, I'd like to
Okay.
have at least one hard copy for us.
Okay.
So
One-
10 is working well for you, it sounds like.
10 has worked well.
Okay.
One thing we can do for the 10 copies is for the plans themselves to be 1117, unless you all have a preference for full-size plans, tends to cut down on paper in the bulk of your files.
I almost never want a copy if I have online access. So it's going to be what works well for Laura. The less for me from a higher view is better. I've had no issues with reading what I can see electronically with plans. I'm-
I think one full-size set is appropriate, but after that, I think I'm good with 10, 11 by 17s.
I'm fine with that, and
It's generally,
I would say if you
Enough.
need them, give them, or get them online.
Again, if I may interject, like,
Sure.
copies to scale are necessary to make sure things are in proper scale. So if we have something that's in the proper scale, we can determine exactly what it is, it's fine. And then whatever other copies are adequate.
Do you,
so the one full-size, Paul, is good to have, and then, but the ones to just kind of glance at, the other 10, fine on the 11 by 17?
Again, like for various permitting reasons, you need things to exact scale to make sure everything's in proportions that can be reviewed properly. For our purposes here, I think we're just having it for record and review. So I don't think the exact scale is super germane to this. I mean, I could be wrong,
I
but
mean,
I
if
think
I may, I
one
think they do need to be an
proper-
accurate scale.
proper scale
peer
copy is
review.
adequate, and everything else is just for review.
yeah, sorry, go ahead, Laura.
No, I was just saying, I think the scale does need to be accurate because we submit them to peer review and they are going to be the ones taking a look at it and doing the measurements and all of that. So if we submit a plan that's not to scale, it's,
Yeah.
they may say, oh, this doesn't meet a setback when in fact it actually does, but the scale was off.
Okay. Do you need copies to scale in your office for people to review, you think?
No,
Or, no, okay.
I mean, we could go fewer copies.
Well, what we can also do is add something on a full set of plans in the next section under section 5 for review fees. We can make sure that is in there if it's not already in there. So make sure that any peer reviewer gets a full set at scale.
Did, like a hard copy? Because we haven't given them hard copies to date.
That they just work off of a computer and then they
Electronic
can
copy,
scale.
yeah.
And that's fine, so, I mean, I'm agnostic on 4.3, whether you do 11.17 for the extra copies or not. Some people like to fold out the big copy, I kind of do,
Yeah.
personally, but I also understand the desire not to have giant size files over and over again. I do find myself
Well-
looking at them more electronically than anything else.
I generally look electronically, but absolutely they have to be to scale, for those who need them to be to scale, but for me, electronics are adequate. The other concern I often have when we keep copies on copies is the storage and, so just so I'm not misunderstanding, do we have a scale copy electronically too?
Yes.
Okay.
I mean,
so-
they should all be to scale, I would say.
Yeah, because of record retention, there's been some issues over the year with the town and paper record retention. So I'm,
But, yeah, I kind of come, whereas if there's a physical copy, full scale, the big one
Yeah.
available with the town clerk or in the building department, I think that's adequate for the full size, and everything after that, as long as it's the scale, could certainly be reduced in my mind. I agree.
Okay. I
Okay.
mean, we realistically probably only need 5, because that would give one copy for me, one for the conservation, one for building, one for select board, one for planning board, because those are the departments that frequently request hard copies. And then we do have the line in there that,
Yep.
you know, should the board require additional copies, the applicant will provide those at their expense. So
Right, right,
do you want to
okay.
change it to 5? Are you guys okay with 5?
Yeah, 5 sounds good to me.
5 sounds good.
5 sounds like we just cut it in half,
All right.
and that frees up your time,
Okay.
Yeah.
which is
Saves
very
them
valuable,
time.
highly valuable. I had another comment in this section. And this may not go in this section. We have talked about the timing to receive the documents on a number of different meetings. Before we have a scheduled meeting for, just even today, I received a around 1:30 email to read documents for this evening. As much as I appreciate that those could not be read. So can we put something of that in effect without, I don't think we
Sure.
can.
No, I think we can, that
We've
all,
talked about this in the past. I'm not saying a hard date, but like an expectation.
I think it's a great idea, and I
Why
think
don't we-
honestly, it'd be a week before, you know, no, because honestly, like, it's
Problematic.
yeah, because it's, I mean, we're all volunteers, and most of this for me ends up on the weekends, right, trying to catch up, or a late evening, so 24 hours or 40 hours in advance. is
Yeah,
just
I
not
did a
enough.
cut on this over the weekend. This is
why
what-
don't we add a section 4.5 that has the 7-day rule for submission of supplementary information?
Yep.
We'll
It's
come up
really,
with
that's the
language for
bulk
that.
of the problem, is the last
Yeah.
minute, yeah.
Yeah,
You know,
Is 10 days too long?
I think it's,
Thinking about when I post the agenda a week before the meeting. If I get the materials 7 days before the meeting, it's not going to go up with the agenda. I could always
but,
post a revised packet with it, but
yeah, I mean, the agenda is, we don't need to state what all the materials are.
no,
for
but
the
I do
agenda.
post the meeting packet, which is all the materials
I
that we're
mean, the
using.
standard is generally 7 days. That's
Yep.
what
Okay.
most boards are doing,
That's fine.
so.
great comment.
Yeah, really good.
Okay.
I want to go back to section 4.1.15. I took out the thing on the monitoring plan. That's something we do at the end, where we have requirements for a monitoring plan. We might ask them, but those are also really canned. The state has requirements for monitoring. We add that as a condition in every permit. We don't need to repeat that here, so I took it out. The filing fees under 4.2, Laura and I kind of talked about this. Is it too much? Is it enough? This is about kind of right in the middle of kind of what I've seen.
Okay.
You know, filing fees always have to be reflective of the administrative costs in managing a project. It doesn't have to be exact numbers, it just has to be a reasonable approximation, whether those filing fees cover Laura's services, folks that may be reviewing plans, not the peer reviewers, the folks that help us put on these hearings, all those other things, down to paper clips, everything else. It adds up over time, and this is kind of a number. I mean, I've seen towns do like 6, 7, 8,000. I just don't see how you could justify that. I think the 3,000 plus $100 per unit is an okay number for a for-profit, and then the nonprofits, and then there's public agencies too that, which we don't see much of in 40Bs. And we don't see much in the nonprofits either, so.
And this is separate and distinct from the payment of the review fees of the
It is
consultant.
separate.
This is just really an admin for the town.
Correct.
This is just the filing
Yeah.
fee, yeah.
Yes. And over a 6-month period, those things add up.
I just did the math. If it was a 200-unit project, it's like $23,000. So, I don't know. I defer if there's defer to you guys in terms of looking at other fees. And if you think we're spot on, great. If we think it could be a little bit higher, I don't definitely have an issue going
In
higher.
terms of a public hearing,
Yeah.
I mean, I think it's probably about right. There's, when they get to building permit stage, there's another big fee.
Yep.
So during the permitting, there's a number of other administrative outlays for them. But for the purposes of just conducting this, what we have here, that seems to me to be about a right number for that.
Okay.
And I did look at some surrounding towns that I could find the information. And we are kind of right in the middle of where, some towns are less, some towns are like, I think it was like Medway is astronomical, but we're kind of right in the middle. So,
All right.
do you guys want to keep it?
I
as
think
is,
that
or-
works for me.
Okay.
You guys think that's appropriate?
I don't have any strong feelings on it.
No.
I don't know enough about it to
No.
have strong feelings.
Yeah, if you guys have done
Say
the-
we're in the middle, I'm good.
No, I don't really have any comment on it, no.
Okay. So I eliminated 4.4 because we have no right to require someone to bring a stenographer. And now with all the electronic stuff out there.
stenographer.
Seems useless.
Yeah,
It would make my life easier, but.
it would. But in the same token, we can't compel that. That's not something that we can require that they do. So I took that out.
I had another comment.
Sure.
And it's just a consolidation comment. As you get into the sixes, we address infrastructure across like 6.1.5.1, 6.1.5.3. And
Do you mind if we
I don't
hold
wanna-
that until we get there?
sure, I thought we were there. We're in
No,
four.
we're at, oh, wait.
We're about to do a review.
We're about to 5.
Oh, we're in 5. I can hold that thought, sure.
So most of the review fee stuff, I'm just kind of bringing it up to date with kind of what I see out there. 5.4, I struck the whole thing because a lot of that was about procurement law, and we're not bound by procurement law for peer review consulting services. So we took that out. So there's no need for that. The rest of it is pretty straightforward. Again, we kind of just brought it up to date with the way peer review works it's pursuant to a statute. It's not unique to 40B. It's the same statute that governs the planning board, the zoning board when we're not doing 40Bs, the Conservation Commission, the Board of Health. So it's, we're just kind of making it consistent with those other standards. So all the additions, all the changes that Laura made is just kind of modernizing it a little bit and keeping it in line with the statute more than anything else. So it's not particularly specific to 40B. So, now we're in section 6.
Now we're in 6.
So,
Okay. I'm going to hold the first thought, but I second thought in section 6. This has to do with the section 6.7, retain a minimum of 10% of the site as permanent open space. And I wanted to think about placing the word contiguous in front of permanent open
Sure.
space. And in some, there have been instances where if it's not contiguous, it kind of erodes the concept of open space. So
no, I think
that's where I'm
fair.
coming from, okay?
Yeah, that
Anyway,
makes sense.
Yeah, okay.
I think that's good.
And then, I don't know, other people have thoughts on it.
No, I think it makes sense. Where feasible, contiguous is important. So
Yeah.
I think it's a great
Okay,
comment.
yeah.
Do you want to have just contiguous or contiguous where feasible?
No, it's encouraged anyway. It's only an
encouraged,
encouragement thing,
It's an
so
encouraging
Okay.
word.
All right.
I think we're
Goal.
good there. It's already as a best efforts kind of thing.
Yeah.
Yeah. Okay.
Then I read my note, and this is not directed necessarily, it's the 6.15.3.1 section. And when I was reading through that, I got a little lost, that if we can somehow consolidate the restatement of infrastructure requirements. It kind of says it a few different ways.
6.1.3, 6.5.3?
No, there's 6.1.5.1, and in 6.1.5.3, both address infrastructure. And infrastructure is again in 6.2.3. So my only point there was, since it's in one section, take it out of the other section.
Okay, I see some redundancy.
You see,
there.
I'm talking only, it's all good, it's just redundant, that's what I'm
Okay.
driving at, not the
Okay,
content.
we can fix the redundancy.
Yeah.
All right. 6.2.6 is kind of my change to kind of make it more exactly the kind of exercise we do with waivers. Exceptions to local regs and requirements. It is the intent of the board that exceptions to local regulations shall be granted only to the extent that such exceptions are necessary to maintain the financial feasibility of the project. Now, it may be that you grant even more extension or exceptions just because it's a really good project. But I want you to retain the power, which is your authority, under 40B to only grant those exceptions and waivers that are necessary to make sure that the project is still financially feasible. Sometimes we go more than that and grant them additional. Sometimes we never even look at the financial side of it. We're doing the waivers that we think make a project smart and effective. But I wanted to mirror that section to mirror what your statutory authority is. And so that's why I made that change. I took out 6.3 and 6.4. It's not really, you don't want to be, I think mostly you don't want to be confined to any specific maximum, so that's not the place for it. We're going to review a project. They can propose something that's 11 stories tall if they want, and 800,000 square feet per building if they want, and we could deny that. I don't want to have limits in here. This is not a bylaw. It's a set of procedural regulations. So I took out those things, and because if you put them in, someone's going to come in with something. It's 40B. They can do something as big as they want, and then you could deny it or change it or do whatever you need to. I don't get in 6.3 then what was 6.5. There was this thing about if 11 or more dwelling units are proposed. I find no link to any regulation or 40B experience on that. I would rather say we should have two means of access to all projects. That's the ideal. It very often doesn't work out that way, but that's our goal. The new 6.4, former 6.6, I just kind of made some changes to effectuate kind of what the current legal landscape is there. I took out 6.6.4 altogether because most of the deed writers will have that provision in it anyway, but not all of them. But in any event, the standard deed writer form that the state requires is going to have that right of first refusal. If it's an ownership unit, it obviously doesn't apply if it's rental. We just don't need it there. The law already covers us in that instance.
I had a small comment for typographical, or I think is a typographical. 6.2.5, where it starts site suitability. There's a semicolon at the end of that section, and it says and then nothing. Do we want to strike that and? I'm
Yeah.
not sure.
Yeah.
Okay. And then, this is actually my last comment. Can we say, to avoid sites which are zoned industrial, can we say that?
Where?
Same section, after you strike the and, which is just a leftover. 6.2.5, it goes on to say, avoid sites which are zoned industrial. Are we allowed to say that?
Yeah.
Okay.
I mean, it's just, we want, again, we can't, it's not a
Okay.
absolute restriction. We just,
Just to,
it's an expression of kind of,
Please don't?
please don't.
Okay.
yeah, just
That's a
in
good
terms of the structure, though, I would just note that it seemed to be set up that way, right? The semicolon relating one paragraph to the next one.
Oh, because.
I don't know, I just,
in
where
that-
the
And
hand
because
went.
that is the penultimate one, you normally have the
Yeah.
and there.
Yeah, so I think that's why it's there.
Okay.
Okay. All right.
The new 6.5, again, we take out shop C.
Yep.
And I've kind of otherwise geared it down because there's new kind of requirements that if we want, and we just talked about this in the last project, if we want a 70% local preference, then we've got to prove why we need it. So I just kind of changed it to match the new EOHLC, or newer EOHLC regulations. In the new 6.6 on parking, I struck the stuff about 2 parking spaces because that's just no longer the standard. People are trying to do less parking. I mean, we're seeing for apartments less in this area where that's more car-dependent area, but in areas where there is more mass transit, we're down to 1.1, and in some cases under that.
Okay.
So you want to be flexible there. Let your consultants and the engineers work out what is effective for their particular site.
Okay.
So, because they just request a waiver anyway.
This is true.
Okay, we already talked about the contiguous open space. 7.1, I offered the opportunity for an extension by the applicant. Then Laura took out on 7.4, provided that the public hearing shall not be closed until the applicant has submitted a proposed memo of decision. Maybe it's hubris, but I like to draft the decisions, and I think we like to draft
I
them.
mean, also, we don't necessarily have the authority, if we're up against a deadline, to say, well, we're not going to close this because we
Right.
don't have this. Like, we
Right.
don't necessarily always have that choice.
Right. And in some instances, the applicant wants us an applicant wants us to deliberate while the hearing's open and come up with a draft. Sometimes an applicant's in a hurry to get it closed and to start the 40-day clock. So we wouldn't see a decision until after the hearing is kind of closed anyway. 7.5, I just kind of struck this stuff. We can impose whatever conditions we want to address local concerns. Now, local concerns is a defined term, but it's also incredibly broad. And there's any manner of conditions we want to do, and I wouldn't want to confine us to a specific list. There's all kinds of stuff we may impose as conditions. And there's a process to challenge those. 7.6, again, try to make this more reflective of the law. We can have it be a 3-year permit, and we can grant extensions for good cause shown. The language beyond 3 years, any undeveloped areas must conform. We can't require that. In fact, the regulations and the guidance say you should probably give extensions almost in every instance when someone comes in. Now, we do normally ask for good cause shown, and if this was a special permit or a variance, we could say, sorry, we don't want to, but it's 40B, and we don't win those battles.
No.
So, let's see. So construction stuff, section 10, struck it all. That's the kind of stuff we put in decisions. Every project's going to be a little different. How we do it over time, our systems of managing construction are going to be different. I think we can reserve all of that for conditions. section, and same thing for completion. We put all that in conditions. As to violations, the enforcement of this is through normal zoning enforcement. So we don't need to include something, and here they're suggesting other processes. They don't exist. If we want, this is like any other permit issued by the zoning board, we enforce through zoning enforcement. So we don't have to include that there. And that's it.
Great.
Good.
A lot of good work.
Yeah. Any other comments by the board? Okay, yeah, I would agree. Excellent work. Do we have any members of the public that want to comment? Either here in person or via Zoom?
I have no hands raised on Zoom.
Okay. Successfully put them all to sleep, so. So then we just, given the edits that have been discussed, I think we just need to take a vote to approve the
Yeah,
edits.
motion to approve
Motion to-
as presented and amended by the board.
Yeah, exactly. Mike, do you want to make that motion?
Oh, yes, make a,
Wanted to-
sorry, I was listening, but I wasn't sure if you wanted me to add to it. I wasn't sure if you wanted me to make any other additional comments. I've just been reading and reviewing these as we go through. Make a motion to approve.
Second?
Okay. Motion to approve the revised rules and regulations as amended this evening has been made and seconded. All in favor, respond with aye. Opposed, nay. Doug?
Aye.
Jamie?
Aye.
Doris?
Aye.
Mike?
Aye.
And Paul?
All right.
All right, and Williams, aye. Thank you very much.
Thank you guys for doing that. It is long overdue.
Okay, that was long. Okay. So, unless we need a break for some reason, I would say we can move right on to agenda item number 2, which is a continuation of 250 Turnpike. So, would you like to, okay, Mr. Charles?
Good evening, everyone. Happy New Year.
Happy New Year.
Thank you. Thanks for being here on this cold evening, coming out to advance this project. As you know, I'm Brian Charvel, the General Counsel and Chief Operating Officer for Ferris Development Group, and we represent the applicant in this matter, FD 250 Turnpike LLC. And of course, this is a proposed comprehensive permit project at 250 Turnpike Road here in Southborough. I'm joined tonight by Louis Levine, our Special Counsel, my Assistant General Counsel, George Bonan, whom you know from our other projects, and also the applicant's engineer from Expedited Engineering, James Tatro, sitting behind me. And we're happy for the hearing to continue.
Great. So, I don't know, I spoke with our peer reviewer, and my suggestion was, we did all have an opportunity to see the dialogue from the shared engineering consultation, which I think seemed like it worked well.
Agreed.
You know, my take on it is there's an awful lot of, yes, applicant to supply, either supply or comply or whatever.
Yes.
Rather than, painfully going through everything there, I've asked him to instead, if he could just sort of address the board and the room with, where you really are with all of that. Not to dwell on the things where you've already agreed, you said we're going to do it. But if there's anything where it's like, well, we have to talk about this a little bit more, or hasn't done yet, let's just, more of a higher level view.
I agree with that.
Okay.
With-
So, would you mind doing that? Yeah, you can use that microphone there. Thank you. Just if you could, just identify yourself and who you're with.
Patrick Bogle from Howard Stein Hudson, the peer reviewer under this project. Like was mentioned, we basically submitted a peer review in December 20th, documenting, going through all the zoning regulations, the Title V regulations, stormwater management, all the towns and, local and state regulations that we had, documented a bunch of different items that we either mentioned, hey, these need to be possibly asked for a waiver from, or you need to meet these for compliance, or whatever the case were, and each one was documented by regulation. So that was kind of how the letter was spelled out. In January 14th, the applicant's engineer from Expert Engineer and I had a discussion to kind of go over some of these items and talk about where we either agreed or had some discussion on items such as the really steep slopes on the edge, some really compressed grading that really needed to be addressed to make the site much more manageable as far as slope stability, some ADA grading concerns, which are mentioned here, some Title V concerns, which are spelled out within here as far as some setbacks to wetlands or some mounding analysis, those kind of things. So those are all kind of a lot of technical questions and comments which are outlined within this letter. And then, I brought up things such as, constructability to property lines, one-to-one slopes, a lot of items like that. So the applicant's engineer has gone through and kind of stated, yes, we will comply, we will do these things, we will address these, maybe stated some other items which we will look at maybe compressing some units together instead of going from 3, possibly 3 to 6, and maybe adjust some of those things. So we're basically just going to be waiting to review some of the additional items that the engineer will be looking at on the plans and seeing how those kind of shake out in the new plan revisions. There was some traffic items, making sure that the entrances are compliant, and all those are spelled out on the plans. So basically going through a lot of those items. There was some back and forth about the setbacks to wetlands. I know I was saying, as far as some regulations and some comments from DCR about the 100-foot setback. Their engineer didn't seem to agree to that. And if that's something that gets we maybe need an opinion from DEP on their specific item on, yes, this is 50 feet, or yes, this is 100 feet, then that is definitely a good way to go on that. So, and I would defer to them on those kind of regulations, but.
Yeah, and then, I'm sorry, but there was an email today that came from you. Is that what you're referring to?
Yeah, that was some back and forth correspondence
Yeah.
between the engineer and myself regarding it's a regulation for a 100-foot setback to a
Right.
wetland.
Okay.
Within a wetlands to and tributaries to within the wetlands within tributaries or reservoir areas for water supply areas.
Yep.
So that was the specific regulation for that. And then I gave some correspondence back with additional justification on those. I think that's where we left that, so.
Okay. Very good. All right.
So anything further on that I can address?
Okay, but first, I think I'll be just looking for the applicant, because I think what I'm hearing is there's still a lot more to be delivered, right?
Yeah, we haven't seen a response, any sort of design response back.
Yeah.
With additional drainage comments, additional drainage calculations, additional plan review that we will see. I think there was some environmental analysis that needed to be provided, some traffic comments, a lot of, just items that needed to be fully vetted through.
Okay.
That I had identified in my comment letter.
Okay.
So.
Yeah, I think the first thing is I'd be looking from the applicant, like, what's your outlook on responding to the items that have been highlighted here and resolving or just filling in?
Yes, after filing the updated plan in late November, our goal was for this board to ship it out for peer review, which we appreciate Laura's help in that happening. So
Yep.
you all have gotten memos not just only from HSH on civil engineering,
Yeah.
but also on traffic and wetlands.
Right.
And we have our corresponding experts responding to each of those, not just on engineering that you're hearing tonight.
Okay.
And so our goal coming into tonight was to get HSH's feedback, for James to have the conversation that they did the other week,
Okay.
and then to send in a summary memo. But we've thought, following tonight, that there would be a new plan design. And that's what our goal is to turn to next.
How much time?
What are the board's next scheduled meetings, if I may?
February 12th, and then March something. So, let me see, March 19th.
I don't think we'll need until March 19th, but I think February 12th is too soon. And so if the board would be open to a special meeting in about a month, I think in late February,
Okay.
we'd like to aim for that. Think about, as with other projects, there being enough time both for Mr. Tatro to finish the redesign
Yep.
and for HSH and the others to digest it and give
Yeah.
you feedback.
Okay. Let me just ask first, do we have anything that we're going to be reviewing, anything on the agenda for February 12th?
We do. We have 3 applications.
3
For
applications.
February 12th.
Okay.
Just a note that February 19th is February break, which is why our meeting is on the 12th and not the 19th.
Okay.
So I think if you're looking late February, probably February 20th.
Probably the 26th, yeah.
Yeah.
Okay.
I can do that.
I can do that as well.
I can do that also.
February 26th?
Mike and
Yeah, I think
Paul?
I think that looks good for me.
Okay.
Laura,
Yes.
on the 12th, do we have any 40Bs on the 12th?
No 40Bs, but 3 regular applications.
Just the irregular applications? I may or may not attend, I have to see.
Okay.
I'll let you know.
Are we talking about February 26th?
Yeah,
I mean, correct?
Yeah.
yes.
Okay.
Is that, will that work as well?
Yep.
Yeah.
I think it should, yeah, I think it's 5
If
weeks.
you thought the
from tonight.
19th was going to work, I
No,
imagine.
I think it would be better, the extra week.
Well,
Yep.
okay. Yeah,
Yep.
yeah,
Yep.
yeah.
You want extension for the 180 days?
Yeah, where are we now?
Current
Well, I'm trying
deadline's
to understand what
March 31st.
extension we're looking for.
The current 180 days runs out when?
Our current deadline is March 31st.
For the ending of the hearing.
Yes.
So I mean, we can let it roll if you want.
Yeah.
We're obviously going to need a couple more
Yeah,
hearing dates after that.
I would
understood.
think.
If it's all right that we plan to take it up on the February 26th, that'd be best, because I think we'll have a better sense.
Continue, just make sure that if you request a continuance, that you add to that just an extension accordingly.
We'll do.
So,
Do you want to discuss that now so they can agree to it, so we can submit it? You want to pick a date right now?
If it's all right, I think we'd rather do it on February 26th.
No, I don't mean that. The 100, you even just mentioned the 180 days is about 10 days after the 26th. Is that correct?
It's a month after.
it's about
Is it a month
March
after?
31st.
Okay,
It's,
so
it's
one-
fine to
Yeah.
deal with it in the
Yeah,
next
I think,
wave of
I thought you said
communication.
10 days. We can deal
It
with it
seems
better
fine to me, yeah.
on the 26th.
Yep.
Yeah, we'll have a
Okay.
better idea of how long we have to go.
Did any board members have any questions regarding what the material we had for this evening?
So David, it's okay, I have 4, if you guys are reviewing the site plan or talking about modifying the site plan, I have
Yes.
4
Yes.
quick elements maybe for you guys to consider, just looking at it, because I did review, thank you from HSH for the detailed comments, but some of these are more minor, but because of the proximity of retaining walls and wetlands, the possibility of moving Unit 29 against Unit 3 is really tight in that area. Units 20 and 21 have a very long, deep driveway. Don't know if those can move closer to the cul-de-sac. Units 15 to 19, which are against the butters, also have pretty long driveways, and whether they can be pulled closer to the road. And I'm just looking at depth, because some of the units look like they have a depth of driveway that's, enough for a car, and others look like they're just further back. And it might be topo issues or other things, but, and then the other minor one was units 1 and 2, looks like they could move north a little bit to give some more buffer, Again, you guys own the abutting property, right? But those are just 4, I mean, if you're looking, just want to at least relay those, because it seems like there's a bunch of pinch points, so just, again, it sounds like you guys are reviewing anyways, which is great, but I just wanted to put those, they're more minor, specific items just for you guys to consider, that's all.
Thank you.
And I should update the board and mention that we've remained in good communication with Attorney St. Andre as a representative of interested neighbors. And we've talked with him and mentioned to him that we are, at their request, looking at pulling in some of the units and consolidating. So part of that relates to what the gentleman from HSH mentioned in terms of potentially consolidating a couple of 3-plex units along the southern property line into, say, 1 6-plex, which would have enabled the units to come a little further north and off the property line.
Okay,
And we're also looking at bringing in from the southeast corner units 9, 10, and 11, which also would create more setback. So
Okay.
that is something we hope to include in the next plan. set.
right, okay. Okay. Did anybody else? Did you have other ones, Doug, or just that?
No, at least for the topic tonight, since they reference redoing the site plan, but it sounds great that you're already talking with the neighbors about many of those adjustments anyways, which is great, so.
Yes.
Okay. All right. I don't know if anybody, I don't know if anybody in the public has any questions or comments for this evening. We don't have any hands raised.
No hands raised on Zoom.
Okay.
And I will take this opportunity to mention that our traffic engineer from AK has digested what Mr. Dirk sent all of you and will be sending in responses, or maybe they've come today and they'll be circulated. And there were no major issues there that we saw, so we anticipate being able to accommodate Mr. Dirk's feedback. And then in terms of the wetlands feedback from Lucas, our wetlands engineers at Goddard are in process of speaking directly with them, just as James did with HSH, to try to move ahead on the wetlands noted concerns.
Okay, so we're seeing progress on these other areas as
Yes,
well
sir.
then. Good.
Yes.
Okay, good. All right. Okay.
Dave, one other comment, just because you guys may have heard it, just when we're doing the comprehensive permit regulations, if you guys could get as much information 7 days before the next meeting, it's just, because it will be a lot, and,
Yep.
you know, these memos are long, it'd just be really helpful for us to get that information sooner rather than later, just to make the meeting efficient for all parties.
And James did a yeoman's work of that coming into tonight in terms of responding to HSH, but then I think something trickled in from traffic, for example. But we're committed to a week-out goal as well.
Okay.
At the latest.
Yeah. Just so you guys know, I did get the response to the traffic peer review report. George sent that to me today. I did not distribute it to you guys tonight so as not to clutter everything before the meeting. I will get that out to you first thing tomorrow morning.
Great. Okay.
Should we say that express topics on the 26th will be traffic and wetlands as a way to plan?
I mean, if we if we know we have topics to review, yeah, I think it makes sense. That allows us that much better to prepare in advance.
Yeah, not for it to be to the exclusion of the new
Correct.
plan and HSH.
Right.
But I know we'll want a designated meeting to talk about, or have those as designated topics at future meetings. So how about the 26th?
Yeah, okay. Yeah,
Thank you.
makes sense to me.
Do you want me to have both Lucas and Vanessa and Associates here
Please.
on the 26th?
Yeah.
Yeah,
Okay.
I think so.
And we'll do same for our
Yeah.
corresponding
Okay,
folks.
all right. Okay, then, I think, and if we're agreed on the 26th, we need to take a vote to continue the hearing to February 26th, and that'd be 7, I assume.
It'd be 7 o'clock,
You have
so
nothing
that'll
else,
be the
yeah.
only thing.
Yeah.
Make a motion to continue the hearing to February 26th at 7 PM.
I'll second it.
All right, motion to continue to February 26th, 2025 has been made and seconded. All in favor, respond with aye, opposed nay. Doug?
Aye.
Jamie?
Aye.
Doris?
Aye.
Mike? Take yourself off mute.
Sorry, Ben came home and made a ton of noise. Aye.
And Paul?
All right.
All right, Williams, aye.
Thank you.
Thank you.
All right.
Good to see you.
Thank you. So, just before I get ahead of my... Okay, so the next item on our agenda is approval of meeting minutes, December 11th, 2024, and December 18th, 2024. I could mix this up, but one of them was the really detailed review of the decision on
It was December 11th was the decision.
120. Yeah, okay, that was December 11th.
Mike,
So I did take a look through them. They're long, but to me, they reflect pretty accurately exactly what happened that evening. I don't know if anybody else has any comments on December 11th minutes?
No, I read through. I'm fine with them.
Okay,
They're a very nice job.
as usual, yep. And Mike and Paul, you're good with them?
We are. I am. I won't speak for Paul.
You can
I'm
speak
good.
for Paul.
I'll speak for Paul.
You're free to speak for me, Mike. I'm good.
Absolutely. That's it.
Okay,
Lord.
let's handle December 11th first then. Do we have a motion to approve? The minutes as written?
I'd like to make a motion to approve the December 11th minutes as written.
Second.
All right, motion to approve the December 11th minutes has been made and seconded. In favor, aye. Opposed, nay. Doug?
I'm going to abstain because I was absent.
Okay. Thank you. Jamie?
Aye.
Doris?
Aye.
Mike?
Aye.
Paul?
Aye.
And Williams, aye. Okay.
Bless you.
Now, December 18th.
18th was, hold on,
I was not at that one.
correct.
Yeah, okay.
It was a great short meeting.
It was. It was the variance for 120, and it was
Oh.
a continuance for 250. That was it. It was short and
Yeah,
sweet.
that one, yeah, by comparison, it was short and sweet. There was some debate, but again, my recollection of the meeting and review of the minutes, I think it's captured again very accurately. So I had no problems with it. Anybody else?
No comments.
No comment.
All right, do we have a motion?
Bye, Jay. Thank you.
Make a motion to approve the minutes as drafted.
All right, motion to approve the December 18th, oh, we need a second.
Second.
All right, motion to approve the December 18th minutes has been made and seconded. All in favor, respond with aye, opposed nay. So you were, no, you were here, yeah. Doug?
Aye.
Jamie, you were not. Doris?
Aye.
Yeah. Mike?
Aye.
Paul?
Aye.
And Williams, aye. Okay, that takes care of the minutes. The next business properly before the board, ADU bylaw update. I don't know, do we have an update from any board member, or do you have something? I don't have anything. I'm gonna.
Yeah, I mean, I think Mike, Doris, and Jamie could probably speak to it better than I can, because they've been involved
Okay.
in working with the planning board on drafting some stuff. I do want to note for you guys that the public hearing for that warrant article will open on Monday, the 27th, next week.
Okay.
And I wanted to ask if you would like me to post an agenda. For that.
I cannot go on.
I cannot attend either. I have a
I
conflict.
plan on attending, likely remotely on that.
Okay.
And I would attend.
Yeah, I don't know that I'll be able to.
Mike was at the last one, and I was.
Yeah. What was the date, Laura? I just couldn't catch you.
Yeah, Monday, the 27th, so next
Monday the 27th. Let me just make sure because I'll just continue to plan to attend if I can.
Sure.
Yes, I will.
All right.
So I'll plan. What is that for 6:30?
I don't know. I haven't seen the agenda yet.
Okay. So just shoot that to me. I can definitely run point on this. I saw your emails today, Laura. So I do want to make sure we're not missing pieces of the puzzle. I'm
Yeah.
also, just like Jay, is waiting for the updated regulations to get issued from the Commonwealth after now that the public comment period has been closed. So once we have the updated regs, I'll have a little bit more meat on the bone from the Commonwealth.
Okay.
I don't know, you may want to post an agenda
Okay.
just in case.
I'll post one just in case, and then,
Mike, do you want to talk a little bit about the sense at the last meeting where progress was, or?
If the board really wants to get into it, I feel like
Real
I think-
general, no nitty gritty.
no, for someone who's been around a little while, I feel like we're really on top of things with Jay, with I've been working with Mimi, other board members on our draft regulations. So we've gotten, to me, a lot of progress, and we're actually kind of on point as far as making sure we're doing what we can as a town to have updated regulations on this point. And I feel like we're on time so far instead of playing catch up, which we love to do. I don't know generally if any of the board members want details, but there's a draft that's going around that Jay, Mimi, myself have all worked on and contributed to. Generally, there's been some more contributors as well, And then I think honestly, once we get the final regulations, we'll have a little bit more clarity and understanding of what may or may not be allowed. And then we're going to, bring that to town meeting for vote.
I have one more, because I haven't been able to stay on top of this. So will the ZBA be approving the ADUs or planning board? Who is going to be ZBA?
So
Or who?
this is to allow certain ADUs by right.
Yep.
That's right.
Okay, that's right.
Per the state regulations.
Gotcha.
So I had a couple questions that I sent out earlier today to Mike and to Jay. My biggest question is what happens with people who want to have an ADU that is larger than what is allowed by right? I know the planning board had said they didn't want to include that in the bylaw because then the bylaw would go from needing simple majority at town meeting to needing 2/3 majority at town meeting. However, my question is that if it's passed in its current form, we will no longer allow unprotected ADUs in Southborough. They will be completely stricken from the code, and I don't know if that is what we're going for, or if we want to, if there's a way to keep the existing bylaw for ones that qualify as unprotected, so ones that would be larger than that 900 square foot or 50%. And then I've been doing a little bit of research on the impact to the ZBA in terms of the regulations for the state go into effect on February 2nd. So we have to follow that, but there's a little contradiction with our current bylaw. We have an accessory apartment application coming our way for the March hearing, which is after the state regs go into effect, but before we have a new bylaw. So there's a little bit of gray area here that we're trying to navigate, and I just want to make sure that I'm understanding the full impact to the board so that I can make sure you guys are doing the appropriate process. So I don't know if that makes
Well,
sense.
I was listening in with Mike on the last meeting. It is a high priority that we're going to have ADUs larger than 900 square feet. But the feeling and the consensus is to get this through town meeting.
Right.
Yeah,
So
so then what, yeah, so I know everyone is very on it and aware of it.
yeah. So
Yeah.
I had
And
proposed.
and at other instances where even if you have one by right, but say you're too close to the line,
Yeah.
you'd go to special permit, but,
Yeah. So I had proposed,
yeah.
and I don't know if it's legal, which is why I'm waiting on a response from Jay, but can we leave the existing bylaw in place and just add the new bylaw for the protected ADUs? And then that way, anything that doesn't qualify as protected defaults to the existing
We
bylaw,
don't
and
even-
then we're not
Yeah.
changing it per se, and maybe it wouldn't need that 2/3 vote.
So we call them it's just one of those simple things. We call them accessories, and the state calls them ADUs.
I know.
So that's probably we need the advice. I just think we need the advice.
Yeah.
Yeah, but I feel like we can fumble through it until we get approval. It's pretty clear what's going to be allowed under a protected ADU versus an unprotected ADU. So I think we can fumble our way through.
Yeah, and
that.
until we get there, Mike, don't we just do the best we can to follow what the state has for
Well,
guidance?
Like, it's my understanding, and Jay could, if he's still there, can.
No, he's not, yeah.
No, my understanding from what I've been reading and checking on is for towns that don't have their bylaws approved by that, the amended bylaws by February 2nd in the enactment, they're just going to follow the state guidelines.
Yeah.
And then the towns are most towns are going to follow those pretty specifically, and then there's going to be some subtle changes as to, will towns require site plan approval? Will it require site plan approval for attached as well as detached? There'll just be some nuances and little seasonings that I think the towns will add, but I think we just follow the state guidelines, which I'll be able to. I literally check my emails every day for them just to keep myself abreast of the situation. So,
Okay.
Okay, yeah, I mean, that seems to me that's where we'll fall. Is we don't
Exactly.
have a modified bylaw and the state has something. We're pretty obligated to follow the state
We're
guideline.
just gonna,
Yeah.
we're just gonna follow the regs,
Yeah.
and then again, if it's an unprotected ADU, then it's gonna go back to special permit anyways pursuant to the regs, so that absence of language, I'm less concerned about, because
Okay.
it either is a protected ADU and a special permit isn't allowed, but let's say it's within, they want to build a new structure and it's within the zoning setbacks, well, then they're still going to need a variance and it's an unprotected ADU anyways by definition. So it's either going to fit in the round peg or it's going to fit in the square peg. I mean, it's just that it.
We'll make it work.
Yeah.
Yeah.
No, and we've gotten, even the regs that they've proposed now, as challenging and as confusing as they can be a little bit, I mean, we can figure it out. It's really pretty straightforward.
Great.
Okay,
Yeah, and I can forward anything, if they want to review my notes or Jay's or Mimi's, but I think we're really on top of it.
Yeah, you guys have done great work.
Mike, did they say anything about the feedback that I sent?
Yes, we covered that. And what I can do is I can send you the updated updated regs. We're holding off a little bit, just so you know, until hopefully we get the updated regulations from the AG's office.
okay.
Would you guys like for me to send you the most current draft?
Oh, that'd be perfect. Thanks a
Yeah,
lot.
that'd be great.
All right, I'll distribute
Yeah,
that tomorrow.
but that, we touched base on those exact things that we talked about.
Yes.
Great.
All right. That's our ADU bylaw update. I don't think anybody has anything else. Laura, you did put in the prop business administrative updates. Do you have anything there or not
Yeah,
really?
just a couple things. You know, I had asked David if I could keep this as an ongoing agenda item, just to kind of, almost as my report to you for all the administrative things that are happening, because there's a lot going on. So just briefly, a couple of things I want you guys to be aware of. There is a group of us that has been working on a couple zoning bylaw proposals. So it's me, the building commissioner, members, like representatives from planning, select board, and the economic development committee. So a couple of things that you're going to see coming down the line that I don't think necessarily impact you per se. One is we are proposing a shared parking bylaw that is geared towards allowing commercial uses to have shared parking to kind of cut down on those vast empty parking lots and make it a little bit easier for commercial uses to satisfy their parking requirements. So the public hearing for that is also opening on Monday, the 27th. And then another one that's coming down the line is uses allowed by right within the industrial park district. So this is something Al Hamilton, specifically on the select board, has been kind of spearheading this effort of allowing more uses by right in the industrial park district to kind of encourage more commercial business and, you know, hopefully expand the commercial tax base a little bit. So that's something, that public hearing will probably open in February. Doesn't necessarily have a huge impact on you, aside from the fact that some uses that were only allowed by special permit may now be allowed by right. So I'll send that when I have a more comprehensive draft of that, just so you guys are aware of it. Other administrative things, the easement plan for 120 Turnpike for the 40B, they had 60 days to submit that from the date of filing. We're somewhere around halfway through that. I still haven't received it, but when I do, I will get it to you guys. I have briefed the building commissioner on the conditions included within that 40B decision, just because there's a lot that he needs to be tracking as well, so he and I are partnering a lot on that. Other than that, it's just upcoming meetings. So February 12th, we have 3 special permit applications. One is for signs, one is for multiple principal uses on one lot, and one is for parking, like more than 3 garage bays. So nothing too crazy. And then we have February 26th for 250 Turnpike. And then we have March, I forget what date that was, mid-March. We will have
19th.
19th, thank you. We're having one special permit application that I'm not entirely sure what it is yet, but it's coming. And then that accessory apartment application, which is somebody who wants one that is larger than
We've had a few of those.
by right. We have, but not
Yeah.
with the
Within
state
it,
regs.
right.
So, you know, I think they're
It's
trying
not-
to get
yeah,
that in
okay.
before the bylaw potentially changes. Other than that, I think that's it.
And just a refresher for me, as much as anybody, for the next meeting for 250, our peer reviewers are whom and what are they covering?
So our peer reviewers coming on February 26th will be, I'm not sure who's coming from Lucas Environmental, but they are handling wetlands. And I'm going to follow up a little bit with the applicant on that because there is some time-sensitive stuff in regards to like vernal pools and all that. And then Jeffrey Dirk of the NASA Associates, who did the traffic peer review. Both of those consultants worked on 120 Turnpike as well. So I'll reach out to the two of them tomorrow and see if they can both attend on the 26th.
Yeah, I saw that vernal pool review study. You've got April,
Yeah,
maybe end of April.
Yeah.
And they're gone.
Yeah.
Study it.
so
Okay.
little time sensitive, but I think we have plenty of time to make sure that we address
Well,
that.
it's interesting how they'll do that. Because they're not always out. Yeah, so, the salamanders and the critter
Okay.
crossers. I had it on my thing that you wanted me to give you feedback, what happened with Leah Emerson?
Oh, yeah. So just so the board is aware, I did mean to include this in my updates, thank you. Leah Emerson, who's our Economic Development Coordinator, has been working on a couple grants. So she applied for, it's a technical assistance program grant to look at zoning along Route 9, I believe. And then she's also looking to apply for, it's called a one-stop grant through the state, in partnership with Westborough to look at zoning opportunities along Route 9. So they're hoping to do kind of like a corridor study to see what potential bylaw changes we could do to kind of improve Route 9 zoning a little bit. So I haven't heard any recent updates, but
No, I was, sort of gave her some feedback on the grant application form, some of the parameters, which had a lot to do with community outreach, and she submitted and was waiting. I haven't heard about this. It's submitted, I'm like 90% sure.
yeah, the
This is-
technical assistance one.
Yeah, this is the, just a preliminary review. I want to say it's 25,000 to look at the existing conditions out at Route 9 and the way we're zoning it now.
Yeah,
And if they get that, they keep proceeding to the one-stop grant.
yeah.
But we'll hope we get it.
Yeah, so any opportunities, you know, it's a big focus right now with a lot of departments in town is how can we modernize our zoning bylaws to encourage, you know, appropriate business and some of the stuff in our zoning code is pretty outdated and
Yeah.
probably
that was
needs
in
a little
original-
updating.
a little
Yeah.
bit.
so
Yeah.
we're trying to focus on small changes that make a big impact.
you can have
and
a
Route
pig-
9 feels
You
like
have
the
a
best.
piggery
place.
by right. You know, you can have a piggery by right.
Yeah.
Yeah,
Yep, okay.
yeah, that one's
Yeah.
kind of
I
interesting.
don't, I'm not saying take it out because, you know, it's an option. A fruit stand too. It's an option. I just didn't,
But a gym is tricky. Good luck putting a gym in.
well, I don't know if I want a pickleball court because of the noise and so but they could, if it's out in a big industrial complex and they want to put another pickleball court in.
Yeah. So that's all I have.
All right,
Okay.
Paul,
I think we're good then, Paul.
Paul?
is it go time?
Paul, did
Time.
Paul get a new computer?
Yeah, it's working
Paul's,
today.
Paul's connected
We're
now.
so glad you're with us the
Yeah.
whole night. Which way is it?
You know, something I take offense, you guys making fun of me.
No, not at all.
But yes, I have a new iPad.
There you go.
All right, so I'd like to make a motion to adjourn.
Second.
All right, motion to adjourn has been made, and with a second, all in favor, respond with aye, opposed nay. Doug?
Aye.
Jamie?
Aye.
Doris?
Aye.
Mike?
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 Aye.
Hold up
Yes.
our adjournment. Paul?
2 thumbs up, aye.
Okay, Williams, aye. Thank you very much. That closes our meeting for this evening.
Thanks, guys.
Thanks,
Thank you.
everyone.